Hi, morning. I'm here.
This meeting is being recorded.
Morning.
Hello, good morning, Srikanth.
Very good morning. I'm led to understand that Michael is also joining the same. I believe he's also an arbitrator.
Yeah, so people will be joining in. So I am basically just here to see there are no technical issues. I'm from the tech support.
Very well. So you can hear me, see me clearly, right?
Yes.
So very well. So I'm going to log off or rather switch off my camera until they arrive. Would that
Yeah,
be all right?
no. Yeah, of course.
Very good. See you in a bit.
Yeah.
Assalamu alaikum. Hello, good morning, everyone. Dr. Srikant, are you with us? Probably your mic is on mute.
Yes, yes, I was right here. Assalamu alaikum.
Wa alaikum assalam. Thank you so much for being here on time. And I think should probably give it a couple of minutes just to make sure that the participants basically from both from both parties are here today.
Of course.
So
of course.
I see so far we have 8 participants in this, including the host. So I'll just give it 1 or 2 minutes. If we can start 9:05 sharp, would be great.
That'll be fantastic. So a bit of the introduction of myself to you and the participants as well. I'm an arbitrator based in India, and I sit in 34 international panels. I have frequently advised various governments on various disputes. I've been part of drafting of arbitral law of 4 countries. And then, of course, I would email you out in my the sum of perhaps the qualifications and so on and so forth. So then that's a 1 minute introduction about myself.
Great. In my case, my name is Nasser Rashidi. I'm an expert in basically I've been the director for space policy and regulation for 7 years almost, and before that also was director of policy or senior manager for policy and regulations for cybersecurity here in the government. And before that, I was also the senior manager in telecom regulations in the TDRA, the telecom regulator here. And for 7 years, I was representing the UAE in Geneva in the United Nations resolutions and standards related to cybersecurity and telecommunications, including also, cyberspace, blockchain, and other activities. And a graduate from Berkeley for fintech policy and strategy.
That's fantastic. I mean, it's a pleasure to be here.
I'm here.
So I'll mute myself until we are joined by Michael, perhaps. Michael, I've sat together with Michael in sessions before this, so we'll just wait for Michael, perhaps, who's a third.
Should we? Okay, were we guided that we should wait for Mike to start the session, or?
No, no. I was just making a recommendation. But if we are at 9:05, rather 9:06, if you feel appropriate, we can.
I think we should start. And good morning, everyone. Assalamu alaikum. Thank you for being here. We are here all for the case of the appellant from the digital court of the DIFC. And we are here basically for the appeal of the case as was presented earlier in the main hall discussion. And I would like to start by asking, starting from the appellant, counsel to introduce himself and their team, and then the same thing will be followed by the respondent team. So I'm not sure who is the senior counsel from the appeal team or the appellant team.
Good morning. My name is Mohammed Twaib, and I'm the senior counsel for the appellants, Mr. Payne, and my learned junior is Mr. Daniel Osasek Bosa. He's the junior counsel for the appellants, Mr. Payne.
So you are team of two, am I correct? Or I
Uh,
couldn't hear.
in this group, we are a team of two, but then we are actually a team of four, and then the fourth person is absent because she's sick.
Okay. So you are team. I just want to make sure I get it right. You're two people, right?
We are actually three people.
Three people.
Yes.
Okay. So you are the senior counsel?
Yeah, senior counsel for the appellants, and
Uh-huh.
Daniel Osasek-Bosa, he's the junior counsel for the appellants,
Okay.
and Jafreen Aftab is the senior counsel for the respondents.
Okay. So let's focus on the appellant aspect. Great. And do you have any advisors? Did you have any advisors with you? Just to
No,
know. Okay,
no
great.
advice.
Let's pass it to the respondent counselor. If you can please introduce yourself, starting from the senior and then the junior team if you have, and just let us know if you had any advisors.
Good morning, everyone. My name is
Good
Janatul
morning.
Firdos, and I'm going to be the senior respondent. And I have with me Nasreen Hamid. She's going to be the junior respondent. We are a team of four, so we divided the task between us. So we two will present the respondent side for now.
Great. So just to understand, for the appeal, you will be here on the respondent side, right? So in the respondent part, it will be team of two. Am I correct?
Yes, that's right.
Excellent. You will be the senior and Nasreen will be the junior. Am I correct?
Yep. Yes.
Great. So I think I'll pass it to my colleague here, Dr. Serikant, in case he wanted to make any additional points before we start also the session and basically pass it to the council for the appellant. Dr. Serikant, did you want to make any point or any remarks before we start?
Thank you very much, Mr. President. At the moment, no, except for the time allocation which has been allotted between the teams. If you could get clarity in terms of how much time that they would take, it would be of great help.
Excellent. That's a very good point. Of course, this is a case that is very disputable. And I'm sure that both counsel have their own arguments, but as mentioned by Dr. Serikant, we are bound with time. We're limited with time. Try to make the best out of it. I'm just gonna, I will leave it to each team on how they would like to distribute the time between their senior and junior, but making sure that we hear from both of the participants, and to the best of your arguments for this case. We have a maximum of 90 minutes for the whole session. Actually, we have already lost 10 minutes out of that, so maybe we could try to pass another 5 minutes or so, but not more. Making the intro as short as possible. Please, I would like to pass it to the appellant team or the appellant counsel to present their arguments, with facts, and starting from the senior counselor, and then we're going to hear also from the senior respondent, and then in case there is a rebuttal, it could happen from the appellant, and then from the junior appellant counsel, and then the senior appellant counsel, and then we're going to end with the junior as well as senior respondent. Should I repeat the order or is it clear?
It is clear.
Are you aware of the order for the arguments here to be made and the hearing?
Can you repeat yourself?
Sure. I'm just gonna share something quickly here, and I'll share with you basically the preferred order of the hearing that will make it as efficient according to the common practice here. Just a second. Could you see my screen?
Yes.
This is, in our view, this is the best practice here. In terms of allocating the time, each team has 45 minutes in total. So you need to make the best out of that. But this is the preferred order. Please take note of that. Thank you. I think I will pass it then to the senior appellant counsel to basically start his point of view for the appeal. So that will be Mr. Mohammed Tuway.
Good morning, everyone.
Good morning.
Yeah. So may it please the court, my name is Mohammed Twaib, and I'm the senior counsel for the appellants, Mr. Leith Payne. My learned junior Daniel Osas Igbosa is the junior counsel for the appellant. The senior and junior counsel for the respondents are Jafreen Aftab and myself. For the benefit of your honor, I would like to state the facts of the case. The facts of the case are: Clevity is an online platform where users can create an account and trade in cryptocurrency, and users need to have at least 50,000 US dollars to trade in cryptocurrencies. Ms. Razrani and Mr. Leith Payne are both users of the Clevity platform. Ms. Razrani programmed Alpha to automatically buy a cryptocurrency called Yapil from Clevity at the best possible price, whereas Payne created an algorithm called Beta, which is coded in such a way that if there are many users selling Yapil, then the program Beta would sell it at an average price. However, if there are no users selling Yapil, then the program Beta would sell it at a highly inflated price. So one day, Clevity's software underwent a routine upgrade. As a result, Clevity wrongly excluded the market users who had less than 200,000 US dollars as a margin in their accounts rather than 50,000 US dollars margin as intended previously. Ms. Razrani and Mr. Payne were coincidentally the only users who had $200,000 in their account. In the absence of any other market activity and no other users who could trade in cryptocurrency, Beta offered to sell Yapil at its default price, and Alpha agreed to buy it. The disputed trade was settled by Clevity platform, which recorded the transfer of 100 Yapil coins from Payne to Razi and debited her account with 250,000 US dollars. When Ms. Razrani discovered what had happened, she issued proceedings in the DIFC Court's Digital Economy Court seeking damages. Payne argued that there could not be a relevant mistake within Article 37 of the DIFC contract law of digital economy, but the Digital Economy Court dismissed both of Payne's application for damages. So these were the facts of the case. So I will be addressing your honor on the first ground of appeal, which is as follows. The first instance court made an error in concluding that because Clevity operated a distributed ledger with a node in the DIFC court had jurisdiction over the claim by Ms. Razi against Mr. Payne under Article 5, subsection A of the Judicial Authority Law. Your Honor, this concludes my first ground of appeal. My learned junior will be addressing the second ground of appeal, which is the first instance court made an error in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37, subsection 1A of the DIFC contract law that Ms. Razi show that a reasonable trader with knowledge of the circumstances surrounding the transaction, would have concluded that disputed trade was the result of an error. So I have two submissions to make, which are, my first submission is the Securities Law of Sultanate of Oman 2022 regulates financial contracts or debt instruments which are negotiable and transferable, such as stocks, bonds, cryptocurrency, etc. My second submission is that the respondent, Ms. Razani, does not reside within DIFC. Instead, she resides outside DIFC. For the benefit of your honor, I will begin with my first submission. The Securities Law of the Sultanate of Oman 2022 regulates financial contracts or debt instruments which are negotiable and transferable, such as stocks, bonds, cryptocurrencies, and etc. Article 1, subsection A of the Securities Law of Oman states that any financial contract or ownership right or debt instrument which are negotiable and transferable, such as stocks, bonds, sukuks, crypto, and other securities specifically mentioned in this law or determined by the board, are regulated by the Oman government. Article 2, subsection E of the Securities Law of Oman 2022 states that one of the main objectives of this law is to manage risks arising from or related to securities transactions. Securities here are defined as I've said previously, any financial contract or ownership right or debt instrument which are negotiable and transferable. For example, stocks, bonds, sukuks, crypto, etc. Thus, this implies that if a dispute arises, then the Oman court has jurisdiction. Article 3 of the Securities Law states that no person shall carry out securities businesses or act as securities service or product providers without having a valid license from Capital Market Authority. Capital Market Authority is one of the government regulated bodies in Oman. So this means that without a valid license, a person cannot trade in cryptocurrencies. Thus, it can be implied that Payne would most likely have had a license to trade cryptocurrency in Oman, and hence Oman court has jurisdiction. Article 6, subsection G of the Securities Law states that Capital Market Authority shall assume the following to execute the provisions of this law: agreeing to application of technologies, virtual digital investments, or any products or services in the areas related to the provisions of this law are set out in this regulation. This further implies that Oman courts do have a jurisdiction when it comes to cryptocurrencies and any other financial contracts or debt instruments. I would like to state my last law of securities law. Article 29 of the Securities Law 2022 of Oman states that securities shall only be issued, traded, and kept electronically. This means that Oman imposes regulations on virtual assets like stocks, bonds, cryptocurrencies, etc. Okay. With that, Your Honor, this concludes my first submission for the appellant. I would like to move on to my second submission. The appellant was not registered and not Ms. Razrani was not registered and she had no presence in the DIFC, and hence DIFC has no jurisdiction. I would be citing a case. So Fetch.ai Limited and Persons Unknown Category A. In this case, it was established that the court granted the claimants a proprietary injunction and a worldwide freezing order against persons unknown who had accessed their trading accounts containing cryptocurrencies and moved them out of the accounts. Bankers' trust orders and Norwich pharmaceutical orders were obtained against the companies that maintained the accounts. permission was granted to serve the proceedings outside the jurisdiction on the defendants, as it was unknown whether they were within or outside the jurisdiction of England and Wales. My second case would be Corinth Pipeworks SA and Barclays Bank PLC 2011. So this was a case which was judged in DIFC courts itself. So in this case, the defendant Barclays Bank, they had many branches in Dubai. One of them was located in DIFC, and the claimants, they filed a case against the branch which was located in DIFC. So in the judgment, Sir Anthony Coleman, DIFC Court's Deputy Chief Justice, rejected arguments put forward by Corinth Pipeworks that the DIFC courts held jurisdiction over matters in which there were many branches of Barclays Bank which were located in Dubai, not just in DIFC. Lawyers on behalf of Corinth were attempting to sue Barclays at the DIFC court, saying that because Barclays Bank PLC was registered at the DIFC, its Dubai branches, including the one claimed to have assisted in an alleged fraud, fell under the DIFC court's jurisdiction. Lord Coleman concluded by saying that this argument was fundamentally defective. So in this case, in our case, it can be implied that although a distributed ledger is located in the DIFC, it does not confirm that the whole transaction between Ms. Razrani and Mr. Leith Payne occurred at DIFC, because there are hundreds of nodes. According to the facts of the case, there are hundreds of nodes located in various parts across the world. So the transaction could have occurred in sorry, excuse me. So the transaction could have occurred in any of the nodes located anywhere in the world. So it's not confirmed that the transaction took place at a node specifically located in DIFC. Thus, it can be concluded that DIFC courts do not have jurisdiction. With that, Your Honor, this concludes my second submission for the appellant. I would like to invite Your Honor to overrule the previous judgment of the first court of instance. And with that, Your Honor, this concludes my submissions for the appellant.
With the permission of Mr. President, I do have certain questions that I would like to pose.
Thank you. Thank you, Mohammed, for your submission. Well noted. I would like to hear from the senior counsel from the respondent. I think it was Ms. Firdaus. If you would like to also make your submission.
Mr. President, if I may pose one question to the appellant.
Yes, please, go ahead.
With your permission. So, appellant counsel, you you mentioned that the jurisdiction does not lie. So, what is your understanding of permanent establishment in terms of international, which we take into account in international taxation, which necessarily implies the place of origin of the transaction or the place of business where the transaction is situated, or rather where the business is situated, should naturally be presumed to be the place where the transaction has a dispute to be settled. So, can you point the DIFC rules which specifically negate or which specifically augment your submission that they do not have the jurisdiction in this particular case?
So according to the DIFC laws, it is specifically mentioned that it is specifically mentioned. I had a doubt regarding your question. Are you saying if the transaction occurred internationally in any other country, would the DIFC still have jurisdiction? Is that what you meant?
No, could you follow through on your first response? According to the DIFC laws, it specifically mentions that it does not have a jurisdiction. Which rule and which law are you referring to?
Uh, I'm, I'm not sure of the exact laws, but in the DIFC's official website, it's mentioned that unless it is expressly stated, and if the establishment is located in the DIFC, then then by default DIFC would have jurisdiction. But then since the transaction could have occurred in any of the other countries and it's not confirmed that the transaction occurred in DIFC, it cannot be confirmed that DIFC has jurisdiction because Clevity is located in many other countries. I hope that answers your question.
Thank you very much.
I could just follow with one just clarification, if possible, from you, Mr. Muhammad, or from the council in general. Does the law number 22 for Sultanate of Oman that you stated, does it cover cryptocurrency specifically? Does it cover that? Is it part of the scope of this law?
So the Securities Law of Oman 2022, it covers any financial contract or ownership right or debt instrument which are negotiable and transferable. So cryptocurrency comes under that definition because it is negotiable and transferable, and it's a financial contract between two people. So it can be implied that cryptocurrency, just like stocks and bonds, come under that come under that law.
So your understanding is cryptocurrency is similar to stocks and bonds. Is that your understanding?
It's not exactly similar to stocks and bonds, but it's partially similar to stocks and bonds since it is not something, it is intangible, it's not something which you can hold, it's something virtual. And stocks and shares of companies are also something which is not tangible, it's not something which you can hold, it's virtual.
Thank you, Mohammed. And just following up on the previous question by Dr. Sergent, just to understand better the DIFC jurisdiction that you were referring to, is your understanding that the DIFC law applies for people registered, or it's at the personal level, or it's actually at the transaction level as well? So the transaction, regardless where the person is, who's doing that transaction, whether he's registered or not, as far as that transaction is by a company that has operation with DIFC. So do you understand my question, Mohammed? When we talk about the jurisdiction, your understanding of DIFC jurisdiction, is it about person registered with DIFC? Is that the scope, or it's also in case the person uses a platform for a company, and the company or a platform, and that platform has operation within DIFC. So the platform is one way or another registered with DIFC, but the users doesn't have to be within or register themselves one by one with the DIFC. So what's your understanding of that? Do you understand my question, or should I repeat
Yes,
it?
I get your question. So DIFC law applies both to individuals and establishments. So for individuals, if there are two individuals who want to contract between each other, they should expressly mention in their contract that DIFC, in case of any dispute, DIFC courts have jurisdiction. But whereas for establishments or companies, their presence in DIFC That's what matters. Even if in the even even if it is not expressly stated that if there is a dispute, DIFC courts have jurisdiction. Even if it's not stated, by default, DIFC laws apply. Uh, if there's an
Because they're both
establishment
registered.
in DIFC.
Yeah. And our case is not the second one. Our case is the first one, the earlier point, which is two
Okay, yeah.
individuals, not really two establishments.
Yes, and these two individuals, they didn't have like a proper contract among themselves, although they were although they met some of the requirements or criteria to form a contract, but they didn't have anything expressly written that if there is a dispute, we will be filing a case in DIFC or Oman court or Dubai court. So it was not mutually agreed that DIFC courts is the jurisdiction. Thus, it can be implied that DIFC courts do not have jurisdiction.
Noted. Noted. Thank you. Dr. Sarikan, do you have other questions, or should we pass it to hear our senior counselor from the respondent side?
None at the moment. Thank you.
Thank you. I think we had Ms. Firdaus representing the respondent party. Please, if you can, Ms. Firdaus, go ahead and start with your respond to what we've just heard from the appellant.
Yes, sure. Can you hear me like clearly? Is it all
Clearly.
right?
Yes.
Okay. All right. So I will proceed now. May it please your lordship, my name is Janatul Firdaus, and I appear as the senior counsel on behalf of the respondent, Ms. Rani. I'll be speaking about the first ground which has been submitted by the respondents. I also have with me my learned co-counsel, Ms. Nasreen Hamid, who will also be speaking, who will be speaking on the second ground on behalf of the respondent. My lord, as you are aware, the appellant has argued that the dismissal of the submissions by the Digital Economy Court judge in the Court of First Instance has erred in concluding that the DIFC has jurisdiction over the disputed trade, and that per the DIFC contract law, the court did not need to examine the state of mind of the programmer when designing the program. However, the respondent asks the court to uphold the decision made in the appeal because of the following grounds that we submit are applicable in the disputed trade that has been mentioned. And secondly, the glitch in the program was an unforeseeable technical error um, and was a unilateral mistake. Henceforth, the disputed trade should be rendered void. Your Honor, your Lordship, for the first ground, I have three submissions to make. If it pleases your Lordship, I will begin with my first submission, which is distributed trade is validated if claims are brought to DIFC and can help with debt recovery proceedings. So Clevity being a distributed ledger having one node on a server based within the DIFC, it authorizes the body to award exclusive jurisdiction to hear and determine civil and commercial cases. In addition to this, Clevity is a party to DIFC and can seek judicial authority at DIFC as per Article 5, Section A, subsection 1. Also, the Digital Economy Court is a specialist division of the DIFC courts according to Part 58, Section 3 of the Digital Economy Court. Accordingly, Article 5, Article 5, Section A, subsection C, it says that the distributed trade is related to DIFC activities. The parties agree in writing that DIFC decision may prevail once it is proven that DIFC has jurisdiction for deciding the present case according to the article mentioned. Likewise, according to the above mentioned legislation, it can be concluded that DIFC has jurisdiction. Alongside, to refer to a case law, one of the recent DIFC Court of Appeal decision for the case of Goyle and others versus Credit Suisse, which is Switzerland, which was a case about guarantee agreements where there were four guarantors who were actually non-DIFC entities, and they actually got they in the decision it was said that it was confirmed that the DIFC is indeed a court of Dubai, and that non-DIFC entities who intend to opt in to the jurisdiction of the DIFC courts can do so. And to quote the judge, Judge Martin, who expressed that the fact that Credit Suisse was a DIFC establishment at the time when the guarantee was signed, it should strongly show that, in conclusion, that there was mutual intention of the parties that the DFC courts were to be included within the meaning of the expression courts of Dubai. So because of that, even though Ms. Rani, she resides in Oman, since both parties have sought help from the DEC for their claims, and more specifically because they have a node that is actually located in DIFC, that is why DIFC has jurisdiction to foresee this case. I will now move on to my second submission, which is that the DEC supports claims for distributed ledger technology. According to Part 58 of the Digital Economy Court, Section 5, it is stated that a digital economy claim can be considered if they fulfill the requirements stated in Part 58, Section 7, which states that a claim relating to the digital economy can be distributed
Ms. Firdaus, I'm just asking if you could probably repeat your final statements or check the internet connection, because we're kind of losing your voice. I don't know if it's just me or other people also facing the same difficulty.
Can someone let me know as well? Because then I'll repeat myself. Do you want me to just repeat the second submission?
The second submission, exactly. It's from the second submission when we start losing your voice.
Okay. I'll try my best to repeat it.
Thank you.
So the second submission is so sorry, just give me a moment. It is about how the DEC supports claims for distributed ledger technology. According to Part 58, Section 5 of the DEC, it stated that a digital economy claim can be considered if they fulfill the requirements stated in Part 58, Section 7, which states that a claim relating to the digital economy can be distributed ledger technology and blockchains. This also includes applications based on blockchain technology, and in this case, the whole dispute is based on blockchain technology and applications related to it. So therefore, even though
we're losing your voice again. May I ask just
there is a node in DIFC. Sorry?
We lost your voice in the past 10 seconds or so, or 15 seconds.
Okay.
Just ask all the other participants to turn their videos on and just their videos off, and just keep only Ms. Firdaus' video on and myself, just in case that would help with the bandwidth.
Okay. It's showing that my internet is all right. I don't know what's happening. I'm so sorry.
No, don't be. Please, if you could just repeat the last part of your, the second part of your final argument.
Sure. Overall, so the main submission is that Part 58, Section 7 states that a claim relating to the digital economy can be distributed ledger technology and blockchain, and it also includes applications based on blockchain technology. So even though Mr. Payne resides in Oman and Ms. Rani resides in Dubai, since there's a node in DIFC and the dispute involves blockchain technology, DIFC has jurisdiction to award a decision on this case. I will now proceed to my third and final submission. Is the network okay so far?
Yes, better now. Please proceed.
Okay, perfect. Okay, so my final submission is that the claim is valid in terms of rules involving financing. When Yapel and Beta made the unfortunate automated digital transaction, this caused Ms. Rani to have a loss and create a claim involving $250,000, which is a lot of money. And all of this happened without both parties even knowing it was taking place. The usage of algorithmic trading was involved in the first place to make things easier and faster for traders like Ms. Rani. However, this case has been different for our client. Moreover, the integrity of the jurisdiction has been questioned, which puts Ms. Rani in a situation where she is actually in debt. Nevertheless, it should be pointed out that unlike the claims by my learned friend on the other side, in the appellant, about how DIFC does not have jurisdiction, according to the DEC rulebook, which it claims that such claims are actually valid because the jurisdiction because if you because involvement of amounts that does not exceed more than 500,000 are valid within the DIFC jurisdiction. So to conclude, these are my three final submissions. Your Lordship, my learned co-counsel will now proceed with the submissions for ground two. Thank you so much.
Thank you, Mr. Dos. Before I pass it back to the junior counsel to speak about the second submission from the appellant. I just want to also seek if the Dr. Serikal has any question he would like to point to Ms. Firdos in her submission or in her response.
At the moment, no. Because we have paucity of time at the moment, no.
Okay. I just had one question to Ms. Firdos about her understanding of the law of Oman, number 22, in terms of security and licensing. If you can just, because you basically make it solely that it's under the DIFC jurisdiction. I just wanted to understand briefly your response about jurisdiction with regards to the law of Oman applicability in here. I didn't quite capture that in your in hearing you. Can you briefly just elaborate your understanding of that?
I'm so sorry. I actually did not make any comments regarding the rulings in Oman. I was just saying that even though Mr. Payne, he resides in Oman, and that Ms. Rani, even though she resides in Dubai, it does not matter who is where at the moment. The fact that both of them seek help from the DFC, and that that blockchain I'm so sorry, just give me a moment. Claims because Part 58, Section 7, it says that the DEC allows claims involving distributed ledger technology and any application for blockchain. And I hope that answered your question.
Yes, I am. That clarifies your understanding of this. Thank you very much. I would like to pass it, I think, according to the order that we had in mind, and the best practice, would like to pass it to the junior counsel from the appellant party. My understanding it was Daniel, if I'm correct.
Yes, correct.
Please, Daniel, if you would like to make your submission and would like to hear you
Thank you.
on the second
May I plead
round.
the court? May I plead the court? My name is Daniel Osas Igbosa. I am the junior appellant to Pine, and I'm here to state my second ground of appeal. May I plead Your Honor to go ahead with second ground of appeal?
Please.
Okay.
Please proceed.
Dispute trade was not a result of the error. The judge also erred in concluding that the disputed trade was as a result of error. If you may plead, Your Honor, can I proceed with my submissions?
Please proceed.
The doctrine of freedom of contract stated that individuals of full capacity being able to freely choose who they contract with and on what terms within the contract. This began in the 19th century when judges believed that people should be able to make their own decisions since they know what is best in their own interest. Under the assumption that nobody would choose on favorable terms, the court simply acted as an umpire, ensuring parties were upholding their promises. Okay? They only interfered in special cases, including those involving misrepresentation or under influence, liability, or illegality. But in this case, there was no misrepresentation, there was no duress, and there was no illegality. If you may, in the case of PSGB versus Boot in 1953, if you may please, Your Lordship, can I give a debrief of the case?
Please.
Okay, so in this case, it shows that once an offer was accepted, the contract is completed. In this case, in another case, there was an offer of, in this case, very case, there is an offer of 10 Yapo coin by our client, Mr. Pine. Okay, he set up this algorithm called Beta, and it was accepted by Alpha, which is an algorithm programmed by Mrs. Razi herself for $250,000. Both the appellant and the defendant are adults. They are of age and they are of a sound mind to go with the algorithm that to program themselves into this. And they also understand the risk that are involved in cryptocurrencies. If in the case of Adams versus Litchell, if you may please, your lordship, can I go ahead with the brief of the case?
You can, but I have one point here to make. How many Apple was the transaction for?
It was 100 Apple.
You mentioned 10. Is that error or intentional?
Sorry, say that again, sir.
I said it was 100 Apple, but I think you mentioned 10.
Oh, okay, my bad. Sorry about that, your lordship. It was 100 Apple coin.
Thank you.
Thank you.
Now you can proceed, of course, to the second part of your argument.
Thank you, Your Honor. So in this case, in the case of Adams and Litchell in 1818, in this case, it said that once claimant paid that amount of money, she accepted the offer, then there is a valid contract. If you would please, Your Honor, can I continue with my second submission?
Please proceed.
Thank you, sir. I would like to establish on Article 43 of the DIFC contract law regarding the loss of a right to void a contract. States, and I quote, if a party is entitled to avoid the contract for a mistake, but the other party declares itself willing to perform the contract as it was understood by the parties entitled to avoidance, the contract is considered to have been concluded as the later party understood it, the other party must make such a declaration or rather such performance promptly after having been informed of the manner in which the party entitled to avoidance had understood the contract and before that party has acted in reliance on a notice of avoidance. If you may, in the case of Henston and Fraser in 1892, if you may please, Your Lordship, can I give the brief of the case, sir?
Please do. And
Thank you.
just if you can
In
be
this-
brief.
Yes, okay, thank you. In this case, the claimant could not revoke the contract after there was an acceptance. If you may please, my Lordship, can I go ahead with my third submission?
Please proceed with the third submission.
Thank you, Your Lordship. I would therefore establish the fact that the other party had lost the right to avoid a contract. Pine sold his 100 cryptocurrency coin for $250,000. Razi's obligation under the contract is to pay $250,000. Since Pine is not avoiding or terminating the contract, we consider the contract to have been concluded by now, and I don't know why we're here. So, moving forward, it is one-side decision which should not be forced on our client, Pine. Rani cannot avoid this contract unless she proves that there is a mistake from our end, which is our client, Pine. The appellant did not do a mistake. We didn't commit any mistake. My client did not commit any mistake. None. Is he responsible for the circumstances because of which transaction occurred? And I think, in our opinion, we think Clavity should be sued and not our client, Mr. Pan. If you may please, Your Leadership, I would like to state this article of DISC code. May I?
Yes, you may, please.
Thank you, Your Honor. Thank you, Your Honor. Article 37 of the DIFC contract law states, and I quote, Part A, if the other party made the same mistake or was also mistaken or caused the mistake or knew or ought to have known of the mistake and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. In this case, it was not our mistake, even if we have to establish that there was a mistake. We didn't foresee this mistake. We didn't commit the mistake. If it may please my Lordship, I would like to conclude my submissions.
Please proceed with your conclusion.
Thank you, Your Lordship. If it may please Your Lordship, I would like to invite the court to rule in favor of the appellant. With that, our Lordship, this concludes my submission. Thank you, sir.
Thank you. I would like to seek if Dr. Serkel has any, Judge Dr. Serkel, if he has any point to the junior counsel from the appellant.
So, what has been the, thank you very much. I do have one question. What has been the prevailing jurisprudence insofar as avoiding a contract, insofar as a mistake is concerned, especially when it comes to complex instruments like DLTs? So, what is your position, appellant?
I'm sorry, I didn't get your question right.
Let me rephrase that. While we understand avoiding or avoidance of contract in traditional terms when it comes to traditional contracts, insofar as crypto and insofar as DLTs are concerned, distributed ledger technologies are concerned, what should be the jurisprudence / the judicial opinions / advisories that we should rely on insofar as the arguments that you just made? Is there any authoritative guidance that we may rely on?
Okay, let me assume I understand your question by trying to bring the question back before I go towards the answer. Is that fine?
Very well.
Okay, thank you. So in my assumption, I assume you are asking me what is my reliance on my defense stating that there was no mistake in the contract. Is that right?
Yes. Can you be very specific to the DLTs and crypto?
Okay. Like in crypto generally, first of all, both the appellant and the defendant, they are both of age, they are both of sound mind, and they are both of this experts. That should be the right word, experts. So we assume, we don't assume, we know that even if we agree that there is an error, it didn't come from us. So we need a proof to show that yes, the error come from us in order for us to say, okay, yes, there was actually an error. But our client set a target for him to do business on the platform. So he's not in any obligation to decide what happened on the platform. So, but my point now is, Mrs. Raznani trying to avoid a contract is unreasonable, unjust, and unfair to our clients because the contract was concluded. That is the reason why I tried to bring more cases forward where a situation whereby if a contract is being concluded, then it can't be void anymore.
Can I follow through on that particular question? Would you have anything from the DIFC courts that you could suggest by way of furthering your argument insofar as this? I'm sure the DIFC courts would have dealt with this particular matter at least peripherally at some instance.
Okay, let me assume I get this question right. Are you asking me if I have a backup from DIFC court to back my claims?
Yes.
Okay, thank you. Let me go back to the previous article I read before, if I may be allowed to do that.
Very briefly, please.
Okay, thank you, sir. Thank you, sir. So in Article 37 of the DIFC contract law stated, a part, it said, if the other party made the same mistake, that is to say, if we made the same mistake, or also mistaken, or caused the mistake, or knew, or ought to have known of the mistake, and it was contrary to reasonable commercial standard of fair and dealings, to leave the mistaken party in error. Okay, moving forward with this article, sir, our defense on this part is we didn't commit any error, we didn't make any mistake, and we were not mistaken. There was no causation on our client's end to cause this mistake, and we didn't foresee anything like that coming. So that is the reason why I was having a claim here that if for any reason anybody should be sued, it should be clarity. That is to say, the appellant do not make a mistake. The appellant did not make a mistake. None. Is he responsible for the circumstances? The appellant is not responsible for the circumstances that occur actually in the course of the transaction. So if anyone should be sued, it should be Clevity, not our appellant, not our client. Thank you, sir.
Thank you, Daniel.
Thank you, sir.
And thank you, Judge Dr. Sarko, for your good question. What's your understanding of mistake, Daniel?
Okay. You know, in mistake, we have 3 types of mistake. Why we have the common mistake, we have unilateral mistake, and why we have a mutual mistake. But if we have to view it from this other part, we were not taking advantage of Mr. Raznaim. No, we were not taking advantage of her. This was not a foreseeable circumstances. This was not what we actually had intention of doing. But we are in business. Our client is in business. Our client is trying as much as possible. That is the reason why the algorithm was set. And that is the reason why I fall back to Clevity, stating that if anyone should be held reliable or responsible, it should be the platform and not our client, because our client is out there for business. So in that, there was no mistake in business. That is how I see it, sir.
Thank you, Daniel.
Thank you, sir.
I think with this, we can, if there is no further comments from His Honor Judge Dr. Circle, we can actually proceed with the junior respondent from the respondent party, and then we can end after that with the junior appellant rebuttal in case there is the senior or the junior appellant rebuttal. So we're gonna proceed with it was Nisreen, Miss Nisreen from the respondent team. Is she with us? Can you hear us? Miss Nisreen, if you are with us, please turn on your camera so we can see you.
Yes, hi, good morning. Am I audible?
Yes, we can hear you, but for some reason I can't see you. Is your camera on?
Yes, it is. I'll just try turning it off.
Okay. Maybe it's an issue from my end. I just want to make sure. Okay, please proceed.
Can you see me now?
I don't know, it's probably a technical issue, but it's okay. I can hear you well until we see how we can sort this out, please. Does everybody else, or does everyone else can see Ms. Nisreen Hamid Awa? Or is it just me who's having a problem with that?
No, we can't see her as well.
I think others can switch off the cameras. I cannot see them. Perhaps only the judges can have the cameras on, and the screen could join in. We will try that.
So I've just switched a few settings. Maybe something has changed now.
If you're using Chrome, you need to allow camera in Chrome.
Yes, I actually did that initially in the beginning of the meeting. Maybe I'll just double check here the settings.
You could try an alternative browser. It should open up over there.
Okay.
Nisreen, we can have up to 20 seconds to sort this out. Otherwise, you could just proceed with audio, or else your senior counsel can actually take it. So you have a few seconds.
Okay. I think I'll just proceed.
Go ahead, please.
Okay. May it please your lordship, my name is Nisreen Hamid, and I
Now
appear
we
as
can see you.
Okay, great. Okay. May it please your lordship, my name is Nisreen Hamid, and I appear as junior counsel representing the respondent, Ms. Rani. I appear alongside my learned co-counsel, Ms. Janatul Firdos, who appeared as senior counsel for the respondent. Your lordship, I will be dealing with the second round, which acknowledges the question whether the glitch in the program was an unforeseeable technical error and whether it was a unilateral mistake. So in relation with the second round, your lordship, I have 3 submissions to make. If it pleases your lordship, I will now begin with my first submission. My lordship, Ms. Razi programmed her software, I know, in such a way to function so as to procure a cryptocurrency called the Apple at the best price on the Clevity platform. As you're aware, my lordship, Clevity underwent a routine upgrade in their system, which indicated that the upgrade happened on a frequent basis. However, during the routine upgrade, a glitch occurred, leading to this disputed trade that we are here for today. So it is important to bring to your lordship's attention that the occurrence of the glitch was unforeseeable and not anticipated, as there was no history of such an occasion since the upgrade had been done numerous times before. So Clevity have undergone this routine, this upgrade a few times before, and no such glitch occurred. So there was no way for any of the parties to actually anticipate this glitch occurring. This is also in line with Article 49, subsection 1 of the DIFC Law number 6, 2004. It is important to assess the intention of Ms. Raz Rani, as it was clear while having programmed the software that she had intended to purchase the Apple at the best possible price under standard market conditions. However, the disputed trade was not carried out under standard market conditions, as the glitch was not typical. So this is not something that the platform was used to occurring. This was basically the first time that this has ever happened during trading on the Clevity platform. Which brings me, Your Lordship, to my second submission. So in assessing the factual condition of the case, it is possible to conclude that Mr. Payne gained excessive advantage as the glitch favored the manner in which the appellant's software was programmed. So Ms. Raz Rani's beta, the program that Mr. Payne programmed, was programmed to sell the Apple at the best possible price. However, it was sold at a very highly inflated price that accounts for unreasonableness, as it may not be sold for the same price if it was not for the occurrence of the glitch. Article 3.10 under subsection 1A of the International Institute for the Unification of Private Law, the appellant had unjust advantage of the situation and took unfair advantage of the respondent's economic distress and lack of bargaining skill, as it was occurred when the respondent was, quote, unsleep and aware of the unusual change. My Lordship, I would like to highlight that Yapple was sold 250 times greater than the prevailing market price, indicating that this trade constituted solely on the basis of the glitch and did not account for a commercial trade under standard market conditions. Considering Article 62 as well, Article 62 subsection 1, the IFC Law number 6 of 2004, in the absence of any indication of the price, the parties generally are charged at the time of the contract conclusion for such performance in comparable circumstances in the trade concerned, or a reasonable price if no such price is available. So the highly inflated price of it being 250 times greater, the respondent side can conclude that this may well be categorized as it being unreasonable. Lastly, my Lordship, I will now move on to my third submission. In accordance with Article 82.1 of the DIFC Law number 6, in the case of a simple obligation to pay non-performance by a party is excused if that party demonstrates that the non-performance was caused by an impediment beyond its control, and that it could not reasonably be expected to have taken the impediment into account at the time of the contract conclusion, or to have avoided it or overcome it or its consequences. Likewise, the glitch was caused beyond the control of the appellant and could not foresee the same, as it was not a common glitch as established before. Furthermore, in line with Article 37.1a, it was also against reasonable commercial standards of fair dealing to leave the incorrect party in error. Henceforth, the respondents were left in a position of error, and the error was so significant that a reasonable person in the same situation as the party would not have reached the same conclusion if the true state of affairs would have been known. Your Lordship, it is for these reasons, and also that have been given by my co-counsel Jennifer Fordos, that I urge you to refuse the appeal. And unless I can be of further assistance, that concludes the submissions for the respondents. Thank you very much.
Thank you, Nisreen, for your submission, and I think you made your points clear. Uh, if Judge Dr. Zika allows me, I would like to point um, question for you, Nisreen. My
Please, please.
question is, thank you. My question for you, Nisreen, is I've looked I've looked at your submission, but I also heard you clearly. There's just one question I have to you. It's related to the previous argument made by um, Danielle from the appellant party. Um, the mistake is coming from the system. What's your legal understanding that this issue should actually be, or this appeal that you originally had, or dispute that you originally raised, um, why didn't you talk about proclivity to take some sort of liability related to this problem? Since the
That actually,
initiation of the error started from a Clivity platform. Why didn't you talk about this part and probably raise some liability related to that in your original dispute?
so they may well be some liability which can be given to the Clevity platform. However, for the basis or for the concern of this dispute that we are trying to resolve at the moment, we had only addressed what the appellant had basically raised against us. So we find that they may well be a reasonable ground for Clevity to take liability for what had happened. However, for the basis of this court at the moment, we are only dealing with what has been raised against us today, which is the appellant's side claiming that this was a lawful and reasonable trade, which we have disputed before the courts today.
Thank you. Okay, I think we're doing well. We have a few minutes left for our session, and I would like to pass it to the senior appellant in case he would like to make further arguments and further elaboration about his submission and argument for this case. Please,
Yes,
Mr. Mohammed, the floor is yours.
yeah. Okay, so first I would like to state what had happened and how we shouldn't be considered liable, and I would also like to state that DIFC courts do not have jurisdiction. So this whole case is is between two individuals. So they should have assessed the risks, and they should. And when the contract was formed, there was no expressly stated clause which mentioned that DIFC courts have jurisdiction, and it's not confirmed that the whole transaction took place at the node located at DIFC. So, so regarding that, there, so regarding that, we can state that DIFC courts do not have jurisdiction. Moreover, the securities law in Oman, which got what do you call, which got inculcated in the Oman law in 2022, which is this year. The securities law in Oman regulates financial contracts for cryptocurrency, bonds, etc. So, so we would also like to state that Oman courts could also have jurisdiction in this case because my client, Mr. Payne, he resides in Oman. Moreover, regarding the regarding the point stated by the senior counsel of the respondent, she mentioned that she mentioned that according to the rule book of the Digital Economy Code, since the claim is below 500,000 dirhams, DIFC courts have jurisdiction. I do not think that's how we should. I don't think that's how we should have our case in DIFC or not. Just because the claim is below 500,000 or not, that does not clarify, or that does not state that this case should be mentioned in this court. And since the small tribunal courts handle cases only below 500,000 dirhams, she mentioned that DIFC courts have jurisdiction. But in our case, it's a matter of 250,000 US dollars. So if you convert it to dirhams, it is 917,500. It's basically about 900,000 dirhams. So these small tribunal courts also do not have jurisdiction. So that's my counter argument.
Thank you. Any further counter rebuttal or counter argument from the senior counsel? From the respondent side. And here we're talking to Ms. Firdaus, if I'm not mistaken.
Yes.
Please.
Sorry, I missed what you said. Could you repeat
If you
it again?
you've just heard the counter argument from the appellant, and I just
Right.
wanted to know if you had any counter argument overall.
I don't have any counter argument, but the only question that I have, I don't know if this is like allowed or not, but if Omani rules would be, if it's like allowed in this, okay, I think I'm not allowed to ask this question. That's fine. I don't have any comments. I'm so sorry.
Okay, thank you. Just Dr. Circle, if you had any points or you would like to raise to any of the two parties in our case.
So the junior counsel for the other side who declined to ask any question. So you're giving up your right of rebuttal? I take that as a yes. So I do not have any further.
Okay. I will wait just in case Ms. Firdaus or Nisreen had to make any further rebuttal. If not, just please declare as you don't have further rebuttal to make or further counter arguments.
We don't have any more
No further
counter arguments.
questions. No further questions, Your Lordship.
Thank you very much. Thank you for presenting your arguments clearly. And I'm just now trying to have a small conversation with the doctor, with Judge Dr. Circle before we come back to you. Just give us a couple of minutes, please.
Excuse me. So
Yes.
shall we exit the meeting and come back after some time, or how does this work?
No, just give us a couple of minutes. Just
So we'll
2
stay in
minutes.
the meeting, right?
Yeah, you can stay in the meeting.
Thank you.
Just trying to learn about this. So thank you again for your time, and thank you for waiting. Myself and Dr. Srikant, the judge, Dr. Srikant, we had a small discussion, and we are here now, of course, we're just going to give you back some feedback in terms of not our judgment and conclusion in terms of the case, but in terms of what we think as students and as participants in this session and this round, you could probably improve. Of course, we will focus more about improvement. The strength that you guys have shown is definitely very clear. All of you had great points, great discussions, great attitude, great energy. We really liked, in general, your participation, your documentations, and so on. So this is really a comment applicable to all. I just want to make sure, can you all hear me? Is my voice clear as I'm going to proceed further with our feedback? So can you all hear me? Is the voice and audio clear?
Yes, we can hear
we
you.
can hear you.
Great. Please, Dr. Srikant, if I miss any of the points that we've discussed, feel free to jump in and give this feedback. So in here, again, we're talking about what we think, in the position of judges, we could have expected, from you, as well as from, if you allow us to be your supporter and your advisors, to tell you what you could do better. And I'm sure that you have an amazing journey in front of you to learn, and continuous learning is just part of the skills for any successful person. I think in general, great work, great efforts. It's obvious. The passion is clear. However, these are a few points that we would like to make to you. One is, I don't know if I should say names or not. Let me know. It's your decision, guys. If you would like me to talk to each one of you, or you would like me to talk, mention names, or just be in general. I'm happy to do either way. Mention name. Okay. Anybody else have a problem with that? To go,
I don't have a problem with that. I actually would prefer names as well.
Excellent, excellent. So I like the spirit. This is a sports spirit, and we're already learning as one team. I think one point that was clear is that for some of you, you were clearly reading. And an example of that was Muhammad, for example, who's a senior counsel, senior of the other team, let me say, from the appellant team. And myself and Dr. Srikant, we came to the same conclusion. And it's not wrong to read, but you read from a certain citation. If you're reading a quote, but you want as much as possible not to show that you're reading to any case or any round that you're making, because you lose passion, and you lose the showcasing that you believe in your argument, that it's coming natural. This, I can say, that was not, just to give an extreme example of the opposite, Daniel in number of points, especially when you're talking to him, is not really reading. The guy was speaking as much as possible. Now, all of you had moments, of course, of not, or seconds of not reading, and the other way around, all of you had seconds of reading. But if you can make speaking more and then reading less, that makes you more strength. Unless, of course, you're reading a particular quote that you would like, that you showcase that I want to be very precise in reading that. So this is one comment, and the same we have felt with Firdaus more than Nisreen. Same thing, more reading than more talking. We liked I said I'm going to talk about the improvement, so I will skip the likes, but I would like to talk about the research. I think you could have done much better research and much more argument. Research to support also your argument. I was surprised from the respondent side when they did not do any search about Oman law, for example. I mean, even if it's not mentioned or it's mentioned, but you should have already expected that this person, since he is in another country, one of the possibilities, he's gonna just say that, you know, this is not under the restriction because I'm in Oman, for example. So you should be aware of what Oman laws, is there any Oman laws related to this, and so on. So that's, for me, is a gap in terms of research that could have been done better in terms of the respondent. I'm gonna say things related to the argument and persuasiveness. Again, because of the reading, you lose a lot of communication and persuasiveness. You could have good facts, but because of reading, you lose the persuasiveness, and, you know, because you add more into the logic and the persuasiveness behind your points when you are talking than when you're just reading. And you find yourself automatically stopping on the right eyes. You have this eye contact, and this plays a big role. Do not underestimate it in the judging aspect. So I think that could have been done better. Another part was the rebuttal. Again, Dr. Serkant and myself, first, we were super surprised that the respondent team did not make any counter argument, especially that the other team, the appellant, made a counter argument and rebuttal. I think you should have made that, and especially that there were some points that you did not, maybe you did not take into account, but you could have at least some general respondent to it. And then, of course, without going into details in case you want to study it further later on. So that was a surprise. Do not do that. Make sure you have if the senior had a counter argument in the end, you should have also make yours to reaffirm your positions, but also to capture some of the points that maybe you did not highlight in your initial submission. Now, on the other side, the appellant team did have, which is great from Muhammad, a rebuttal, but the problem is that it was exactly repeating what he mentioned in the beginning. Now, it's good. Part of your rebuttal is to reconfirm your original positions in case that's your, original. So you can reconfirm that, but you need to use two things. One, as much as possible, other words describing the same conclusion. And the second thing is, if you have heard now the respondent saying some few things, if you can, add a little bit of your feedback and argument to what you have heard from them into your conclusion, that will give it a value. But repeating exactly what you said in the beginning, it just becomes repetitive rather than affirmative. So that was another comment. And again, as I mentioned, if I'm going to talk about the great things we've heard today, that will be a longer time. I was trying to give you my perspective, if you allow me, and consider it. If you wish, it's you know yourself, and more than I do. This is what I saw from outside, and I totally believe that each one of you can of course bring this giant inside of him and to the best outcomes. The game changer today, in my view, was Daniel. Daniel was a game changer, and I had to extract that out of him. I wanted to hear from Daniel that what you mean by mistake, and that it's a mistake is actually not necessarily with us. Maybe collectivity has a problem, and therefore maybe something to deal with that party, that platform, that should be done between. That argument is missing in your submission written, and in oral submission that you made originally was not there. So I had to tease you so you come up with such a strong argument. On the other side, I teased the respondent team with two questions about Oman law and about why didn't you talk about collectivity as being possible liable. Your response wasn't as I expected. So that could have been a really strong counter argument to what Danielle has mentioned earlier. Now, again, all of you has done great. I just wanted to highlight, in real cases, you might get that chance of a question that could turn the case if you pause and come back with a good general argument. Don't go deep if you're not ready for it, but go with a general argument. Like, for example, the argument by Danielle saying mistake could be one of those cases. In all cases, you know, we are, you know, maybe creativity has a liability. It's not our problem. We're here as a trader. Maybe something that general, without going to the detail, without giving me 100 of references, that general argument could be a saver and could be a game changer in some of the cases. This is general, and I'll pass it to Dr. Srikant if I forgot to mention any other points.
Thank you, Mr. President. I completely echo the sentiments which are, I think you've been quite elaborative in your comments, and you've been very, very insightful to the participants. I echo the sentiments. I understand that this was the first round or the first day. There is a palpable nervousness. So all of us, we encounter nervousness. So perhaps what you could do is you could. It's such a novel case. one of the ways that you could get away with, or rather do away with your nervousness, is to have a paper on your side and perhaps take a moment to read it. And when you do that, you show the judge or anyone who is evaluating you that you have thought through in terms of what you are going to say. And B, you have also taken some time out to actually sort out your nervousness. That is one little trick that you can deploy. To be very specific to the participants, I believe Judge Al-Rashidi has been quite exhaustive in his comments. Reading the script is a bit of a dichotomy. So one of the ways that it could be solved is very simply having the camera a little far out, and you could show that you have a laptop in front of you or a computer in front of you, and you could refer to the computer while making your submissions. This is something that you can perhaps pick up by looking at all the tribunals or the courts which typically stream online. So you could go to YouTube and you could look at how counsels argue in these courts. That is a good trick that you could try. All of you could use a little bit more guidance from the DIFC rules and having the citations, having more authoritative guidance would have persuaded us even more. So it would have basically indicated to us that you know what you are talking. That is the other thing. The third thing is, I know that when it comes to rebuttal, you want to be as counter, you want to deliver the maximum counterpunch. So I know that you would have thought of a maximum counterpunch, but it didn't come out because of the fact that you were quite nervous. I'm sure that would be sorted out in the next rounds. So so keep that in mind. This is a round for you to introspect quite a lot in terms of how you've delivered. So take a few moments, go through the comments made by Mr. President a little more thoroughly, and once you do that, then appear for the next round. Then you would see a visible improvement in your preparation of the entire case. So all the best to you, and I wish you good luck in the competition.
All the best.
And I would like to thank Judge Al-Rashidi for his valuable insight. It was a delight to work with you.
Same here. Thank you. It was great inputs from your end as well. And really pleasure working with all of you, with you, Dr. Srikant, and this is really a good journey. All the best. You still have few rounds. I hope that our comments will be of any use, and we hope to see you in the final rounds as well. All the best.
Thank you so much, Judge
Thank you
Nasser
so
and
much.
Dr. Srikant. The feedback was so tailored and very, very comprehensive and useful, and we'll definitely be using this for the rest of our careers and our journeys in the world of law. So thank you so much for taking the time to give us such useful advice.
Same here. All the best. You guys can do it. See you in the finals. Take care.
Thanks a lot for the constructive feedback. Inshallah, I'll be in the finals.
Inshallah. Great. Thank you. Thank you all. I'm not going to mention all the names, but really all of you has done a great job, and all the best on the next rounds. Take care. And thanks to my colleague, Dr. Strickland. All the best. See you. I'm going to leave the meeting.
Thank you. Bye-bye.